If it pleases the court, my name is Singleton, initials JM. Your Honour, before bringing an application under Section 590AA of the Criminal Code to exclude evidence, I would like to highlight the purpose of the Act that is directly relevant to today's proceedings. If I could direct Your Honour's attention to Section 5 of the Police Powers and Responsibilities Act. I note, and would like Your Honour to keep in mind, that the purpose of this Act is to consolidate and rationalise the powers and responsibilities police officers have for investigating offences and enforcing the law, to provide powers necessary for effective modern policing, to provide consistency in the nature and extent of the powers and responsibilities of police officers, to standardise the way the powers and responsibilities of police officers are to be exercised, and, may I emphasise, Your Honour, to ensure fairness to and protect the rights of persons against whom police officers exercise their powers under this Act. Now, on behalf of Mr. Wishbone, Your Honour, the facts of the case are as follows. My client has been charged with 106 offences. He is a Torres Strait Islander and was born on the 29th of June 2000. Your Honour, this makes my client a juvenile. My client was charged by the police, questioned at the scene, and then taken into police custody where further questioning took place. Your Honour, I would like to note at the point of arrest that the police in power would have been clearly aware that my client was both a Torres Strait Islander, meaning an Indigenous person, and a juvenile. This means that the police officers would have been clearly aware of their obligations under both the Police Powers and Responsibilities Act and the regulations. Bearing this in mind, I note that the questioning that took place at the scene was not recorded and no notes were made. The evidence the prosecution is relying on for the first set of questioning is a statement from the police of what they said happened and what they said was said. And, Your Honour, it is my understanding that this statement has not been given to my client for his review. Further to this, my client was then driven to the police station in an unmarked police car with two policemen not in uniform. During this drive, my client was asked whether or not he was responsible for a series of break-in and enters at various points along the drive. Your Honour, what occurred here was gratuitous concurrence. Gratuitous concurrence is explained in the Supreme Court of Queensland Equal Treatment Bench Book 2005 at paragraph 9.7.3 as the tendency of a speaker to agree with the proposition put to him or her, regardless of whether the speaker truly agrees with it or even understands the proposition. Your Honour, what happened here was gratuitous concurrence. During the interview that took place at the police station, my client was not told he was entitled to or allowed to contact his parents or a support person. Instead, an unknown person my client does not know was present during the interview. This person, Your Honour, was a stranger. Your Honour, I now refer you to Section 421 of the Police Powers and Responsibilities Act, where it clearly states that if a police officer reasonably suspects that a person that they wish to question is a child, that child must be allowed to speak to a person of their choosing before questioning commences in a situation where they will not be overheard. In addition to this, the police must also advise the relevant person that they are entitled to speak to a relative, friend, or lawyer pursuant to Section 480 of that same Act. Your Honour, although my client was entitled to speak to a support person, he did not know this person, and this person was a stranger. I submit, on behalf of my client, that had the police followed the procedures set out in the Police Powers and Responsibilities Act, it is highly plausible that a support person of my client's choosing, being his mother, father, siblings, any of them may have cautioned him not to talk to the police and not to make the relevant admissions. In addition to this, Section 431 of the Police Powers and Responsibilities Act and Section 26 of the regulations also state that a police officer himself must caution a relevant person of their right to silence. Your Honour, this did also not occur. I would now like to bring Your Honour's attention back to Section 5 of the Police Powers and Responsibilities Act. The way the police officers handled this case was not effective modern policing. It was not the use of standardised police powers, and above all, Your Honour, it was not fair and did not protect the rights of my client. Your Honour, RV Island and RVLR establishes that Where a record of interview is made in contravention of the Police Powers and Responsibilities Act, the court has discretion to exclude that recording on the grounds of unfairness. Your Honour, this recording was obtained unfairly. Additionally, I refer to the criterion Bunnings and Cross and assert that the police officers handling the situation were reckless. They had a significant amount of time to comply with the rules and regulations should they have chosen to do so. This was not a time-sensitive case, Your Honour. As stated in Advocacy, admitting this evidence would be unfair to my client, who was deprived of both the benefit of legal advice and an independent support person of his choosing, and, most likely, failed to understand his rights, particularly his right to silence. Your Honour, admitting this evidence would be unfair and contrary to public policy. I ask that Your Honour exercise his public policy discretion pursuant to Bunning and Cross to exclude this interview as evidence that was obtained unfairly. I reinforce that those who enforce the law should follow the law. The police officers conducting this interview breached the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Regulation on multiple occasions.